Ciancora, there was legislation enacted here in 2011 which places a charge on the deeds of properties that were designated as special areas of conservation. And we're talking about 1/7 of the country had this particular provision put in by a sleight of hand through a statutory instrument. Now, Minister, what I want to know is why was this introduced? The Department are now beginning to act like the banks, but at least in the case of the banks, the agreement with them is voluntary, and the banks have actually delivered on their half of the bargain by actually putting the money up front.
Denis.
Thank you. The designation of an area of land as a nature conservation site, whether it is a special area of conservation or a special protection area, does not create a burden on a land folio for that area. The actual imposition of a burden on land folios is a matter for the Property Registration Authority of Ireland. Provision is made under Regulation 14.6 and Regulation 18.9 of the European Community's Birds and Natural Habitats Regulations 2011 to facilitate this process for special areas of conservation and special protection areas respectively. However, I have no plans at present to seek the imposition of such burdens.
Deputy Naughten.
One, Minister, you have the authority under law to introduce it with the stroke of a pen if you wish to do so. Two, Minister, if someone goes into the bank tomorrow morning and looks for a loan, the bank will take into account the fact that the lands have been designated and will reduce the value of the land based on that. So in practical terms, there is an actual burden placed on that land. And thirdly, Minister, why, after putting such onus and responsibility on landowners, are you not prepared to compensate them? And just to give you one example of what I'm talking about here, Minister, 781 turf cutters have looked to relocate to bogs that are not designated. At the current rate that your department is going at, it will take another 276 years before all of those turf cutters are relocated.
Minister.
Just want to be clear on the question here, Deputy. There is a provision to allow for what you said there, that a designation may be placed as a burden on a folio. I have no plans to seek the imposition of such burdens.
Minister, the reality is that the burden is already on those properties. Their properties have been devalued, and you have not, and your department have not been prepared to come up with compensation. Now, is it not the case, Minister, that your justification for this is the GLAS scheme, and saying that farmers can avail of GLAS as a form of compensation? I'll give you an example in relation to one farmer in County Roscommon who is on an SPA, a Turlock, and we have many of them in our own county. His choice, if he wants to go into the GLAS scheme, is to give up his intensive farming as a sheep farmer if he wants to go into GLAS, because 1/3 of his farm will be sterilised for 6 months of the year under the conditions that are laid down by GLAS. So the reality is, for quite a number of farmers within designated areas, it is not feasible to go into GLAS. And you have not had a compensation scheme in place since 2010. In light of the fact that you have designated these lands, you have imposed a practical burden on it, you have legislation that can, at the stroke of a pen, put a legal burden on it, will you now put and deliver on the compensation that should be provided legitimately to those farmers?
The question the Deputy has raised, it's not about that. The matter isn't covered in the question that's put before me today. But I want to go back and say, to be very clear here, I have no plans to register a burden on land certificates.
Minister, are you going to answer any of the questions that I've asked you? And why was the legislation introduced in 2011 through a statutory instrument to actually legally place a burden on 1/7 of the lands of this state? And when you take into account the amount of lands that are already in public ownership, along with this, we are literally taking, by the stroke of a pen, possession in practical terms of these particular lands, because farmers cannot carry out works on those lands without getting the authorised and written permission from you, Minister. So why was that legislation introduced if you have no plans to place a burden, a legal burden, when there is already in practical terms a burden on those lands? And why are you turning your back on those particular farmers and not providing them with legitimate compensation for the legal responsibility that you are now placing on them?
Minister.
Deputy, I'm not turning my back on any farmers. I've answered a question earlier regarding the farmers that have areas or land in designated areas, and under the law scheme on the rural development, okay, well, under that scheme there is, those farmers will get priority. And just on the legislation that you're talking about, I will find out exactly the details around it, but I understand that the legal agreement for raised bogs, special areas of conservations, which applications under the cessation of turf cutting scheme sign, provides for the right to enter onto the property and carry out works in the context of the restoration to be placed as a burden on the folio under which the property is registered, and a burden preventing this is to do with turf cutting, preventing the cutting of turf and or the removal of turf from the property to be placed on the folio under which the property is registered. The agreement also provides that if a site is undesignated, then these burdens can be removed from the folio. In addition, the legal agreement provides for the registration of notice of the agreement on the folio under which the property is registered. I just want to go back again to say that I have no plans to register burdens on folios.
Right, no, sorry.